SJC-12100, Commonwealth versus Julie Corey.
Good morning, Your Honor. May it please the Court, I'm Janet Pumphrey for Julie Corey. I'd like to begin, if I may, with the 33E argument. I gave you in my brief, and also especially in the reply brief, basically 33E cases that have been given 33E consideration in three different batches. One is where the case may have legally sufficient but far from overwhelming evidence. That's this case. Cases where the court considered a mental health issue. That's this case. And cases where the court considered the defendant's character, and that's this case. So psychiatric illness. She was mentally impaired for her entire life with depression, and then after her miscarriage, she had postpartum depression that affected her ability to make decisions in a normal manner or to appreciate the consequences of her actions and her choices. She just didn't understand that keeping the baby and calling the baby her own was not the thing to do. She had a mood disorder, she had postpartum psychosis, and it just really was caused a delusional belief that she could keep the baby and that was appropriate and ethical. Moreover, mental illness like voluntary intoxication has bared upon the specific intent required for murder in the first degree. The unusual circumstances of this case make it really appropriate for 33E consideration. But more importantly is my second batch of cases, no overwhelming evidence of guilt. Tito Rodriguez's motives and Julie Corey motives for this murder are like night and day. At the time of Haynes's murder, Rodriguez had a new girlfriend whom he planned to marry, and in fact, on the very morning when they discovered Darlene Haynes's body, he was at the city hall getting a marriage license to marry someone else. He carefully planned this murder. He found somebody who wanted a baby, and according to the Commonwealth's only closing argument, Julie Corey's only motive for murdering her friends was wanting a baby. Rodriguez's powerful motive was wanting to marry his new girlfriend and eliminate his payments to Haynes and keep his baby alive. The brutality of this murder. Haynes died of multiple blunt force trauma to the head, which broke her skull. Then she was strangled with an electric cord wrapped twice around her neck, and the killer cut into her abdomen and removed her uterus, ovaries, and tubes. The prosecutor described this as a crime of passion, and it certainly was. Corey had no anger against her friend. The victim was her friend. She only wanted the baby that Rodriguez was going to give her. Rodriguez had even attempted to kill his previous girlfriend in exactly the same way. He grabbed her, he put a rope around her neck, choked her, and saying he was going to hang her, and that it would only hurt for a minute, and then she would be dead. Rodriguez was an angry, hostile man who had a pattern of violence against women. Corey had no violent history at all. But most importantly, the night of the murder, there were multiple men. There was a lot of testimony. There were multiple men going in and out of the victim's apartment. From 2 o'clock to 2:30, there was banging and water running. At 4:30, there was banging and furniture. Tito Rodriguez was definitely there because his DNA was mixed with the baby's DNA on the first aid kit. So he probably handled the baby after he took the baby out of the womb and gave the baby to Julie Corey. The next day, he was seen walking away from the cemetery with dirty hands, and the implication is that he buried the extra body parts in the cemetery. Timothy Tripp climbed into the apartment window at 10:30 or 11. He pulled down the blinds so nobody could see him. When a witness came and said they were to take a table out of the apartment, he wouldn't let him in, and he blocked the door. On Sunday, Tripp and Davio were in the apartment, and they dumped water out of a fish bowl, and they appeared to be all sweaty and nervous and tried to hide their faces. Davio, again, was on the back porch the night of the murder. He was seen going into a window, and the men were nervous and not making eye contact. Not a single eyewitness testified that they heard a baby that night. If Julie Corey had been there and had committed this murder, caring for a newborn baby and simultaneously extensively cleaning up over the course of hours, somebody would have heard the baby cry. There was no hearing of the baby cry, but they heard a lot of other things going on. In short, 5 men coming in and out of the apartment of the night of the murder, plus over the next few days. And the only evidence that Corey was there was an elderly woman's hearsay statement that was not admitted for the truth. I won't go through the various aspects of the inadequate police investigation. I've made that argument in my brief, and it's just episode after episode, things that they should have done because the guilt really was going towards other people and not towards Julie Corey.
Counsel, may I ask you, to whom does the benefit of the light most favorable belong to?
Oh, the light most favorable, it belongs to the Commonwealth.
So when you're listing all of these things, it sounds like you're asking us to look to this in the light most favorable to you.
Well, I'm asking you to look at the facts and basically the third-party culprit.
I am looking at the facts because there's a whole lot of facts that implicate your client that you're not talking about, which is why I'm asking that. You go through this litany of all of these things
Exactly.
to look in favor of your client, but your client showed up with the baby.
That's the
right?
most, that's,
Right?
go ahead.
Your client had the baby.
That's right.
But the third-party culprit that you're saying had all of this motivation to do this incredibly terrible crime didn't have the baby.
That's exactly right.
Didn't present the baby as their own and having delivered that baby and fake birth certificates and all of the rest of this stuff. So I'm finding it a little bit interesting that you're raising all of this, but I'm trying to figure out how does that inform our standard of review here?
Well, there's absolutely no doubt that Julie Corey had the baby, and I think that was sort of the overwhelming issue before the jury was, how did she get the baby if she was not the murderer? And I think that she had the baby.
Well, isn't the verdict telling you how where they landed because she was
exactly. Right. Well, I'm saying that this is appropriate for 33E for either a second degree or voluntary or a manslaughter, or even a insufficient evidence of guilt. If you take, I was listening to my brother's argument and thinking insufficient evidence of guilt. There's really not much guilt against Julie Corey. She was definitely there. She definitely had the baby. Her affidavit says, yes, she showed up. He called her, Rodriguez called her and said, come get the baby, and so she went. Her cell phone shows that she was there. There was a witness that said she was there, and he gave her the baby. It's explainable. Rodriguez acted like a guilty man. When he was called at trial to testify, he asserted his Fifth Amendment privilege. At no time in his police interview did Rodriguez ask what happened to the baby. Is my baby okay? He never asked that because he knew the baby was okay because he gave the baby to Julie Corey. He knew that Haynes was dead because he killed her. Julie Corey was not involved in this extensive cover-up. The cover-up lasted for two more solid days with men coming in and out of the apartment. They were acting furtively, conspiratorially, and she was not there because she was showing the baby to other people during this time. There was evidence of that, and then she went to New Hampshire. There was evidence of that, so she wasn't even around for the days after the murder. Her cell phone records show that she was there in the early evening, but not in the later part of the night.
Yeah, which is the problem of the issue you raised about ineffective assistance that Judge Kenton Walker, I thought, dealt with in the motion for new trial.
Exactly. Can I just finish this part and then I'll move on? Yeah, thank you. Rodriguez was a personal care assistant or paramedic, so he had these skills to cut into her and take the baby out alive and then take out the other organs. Corey did not have those skills. And finally, Corey and the victim were friends. I gave you the Sight case and the Jones case. There's no evidence of animosity between them. She had really all she wanted was the baby. So in conclusion, with the 33E argument, I gave you cases of legally sufficient but far from overwhelming evidence of guilt, cases where the court considered a defendant's mental health, and cases where the court considered a defendant's character. In all of those cases, the court reduced the verdict to second degree or manslaughter, or perhaps a not guilty for insufficient evidence. The cell phone, if I can move on just a second, Graziano. The Commonwealth's expert really expertly described how when her cell phone was not recording anything, she in her affidavit she was asleep and she was not on the cell phone, but she could have been driving someplace else and just it was not picking up.
This is deference to Judge Kenton Walker, right? Because
that's right.
She trial judge and she had the
Exactly.
hearing and heard your expert and Commonwealth's
Exactly,
expert.
she was both the trial and the motion for news. And she relied on the trial court's reasoning for not calling the cell phone expert. He said that the trial counsel said that he decided because he believed that the third-party defense, the third-party culprit defense was really strong, and his Bowden defense was strong, and they were strong. But the cell phone expert would have added to that, and he could certainly add to that.
I don't get that, because if the defense is that she was there, she ends up with the baby, and we have these lapses where nobody knows
yeah.
from the cell phone, because I think the way the motion for new trial is phrased is promises a little bit too much. It says that this is going to exculpate her, or it would be impossible for her to commit this crime.
Well,
I don't get the impossible part,
I think
but I think the stronger defense, of course, was she was there, she ends up with the baby, but this is an act that takes a lot of people
a lot of time.
and a lot of time.
That's
and
right.
Guess who did it? The guys did it.
Exactly.
To be
exactly.
misogynistic, I guess. But
And that's basically what I'm arguing, is that she was definitely there. Her cell phone records say that she was there. And the gaps, when her cell phone was not active, those are gaps throughout the night, in between like 2 o'clock to 4 o'clock and 4 o'clock to 6 o'clock. And if she had, in that time, driven back across Worcester and gone back to 94 Southgate, and then gone back to the other side of Worcester, that really wouldn't make a whole lot of sense, because the cleanup was just huge. And as I said, the days after the murder, she was not even, she certainly wasn't at 94 Southgate. She was showing off the baby and making people believe the baby was her own. And with the extensive cleanup that took place over the next 2 days and at that night, again, she had the baby during this time. And
Why would she have had to be there for the cleanup in order for?
well, somebody had to do the cleanup.
Well, but she was a part of. She could have been a part of the whole plan to.
Well, had she been there, had she really been there and had all these men with her, she still had the baby, and then nobody heard the baby. I mean, Julie Corey had the baby, and so I would argue that she wasn't there. She picked up the baby and then she left and didn't come back. I mean, the third-party defense culprit defense was just as expertly established by the trial counsel. But I think if he had added the cell phone expert to testify, he could have made it, could have argued to the jury it was really impossible for her to be the murderer, because she may have been there, but she wasn't there for that entire time, the entire time of the cleanup.
I'm still, if you could help me understand that, I still don't understand how, if this expert had testified the way you just described, how that would have been helpful to the defense with all of the other evidence that you're discounting quite dramatically, but how that would have helped you.
Discounting that she had the baby?
No, discounting all of the evidence that inculpates your client.
Oh, that inculpates my client. What, besides having the baby, what other evidence really is there? She was there.
Again, I go back, and I'm not going to do a slow walk through the evidence, but there's powerful evidence of motive of your client, who was deathly afraid that she was going to lose the love of her paramour if she didn't have his baby. That evidence was before the jury.
It was.
So I know you've made mention of the fact that that the victim's boyfriend was getting married and going off to live this other life, but the jury had evidence that your client needed, or in her mind, thought she needed to have the baby, to save her relationship. So again, now when you're telling me that the fact that putting her there and using the cell phone, that was manifestly unreasonable by the trial counsel to not pursue this, I'm just wondering how that would really help you for us to find that.
Well, I guess it really would have helped the third-party culprit defense, is what it would have helped, because Julie Corey was there. There's no doubt that she was there. But I think if you had the cell phone evidence, again, she would have to transverse Worcester a number of times, and that just doesn't compute with the evidence. The evidence of constant cleaning up and going in and out of the apartment. Somebody was doing that, and it was 5 men.
I'm trying to understand why you're saying that she had to have been part of the whole thing, including the cleanup. And I mean, why is that? Why would that show that she wasn't part of the killing of
Well,
the victim.
my argument is that she wasn't part of the killing.
I
She-
understand
she-
that.
My argument was that she perhaps knew about the killing, and I don't know whether that's true or not, but she was told to come and pick up a baby, and she did that, and that's all she did.
She was told to come to pick up the baby in an apartment where people are cleaning up after a
Exactly,
gruesome murder
exactly.
of who you described was her friend.
Yeah,
And her, and the logical extension of that is, go off to New Hampshire and show off this baby as your own.
exactly.
Okay.
And that's exactly what happened.
What about the DNA evidence that on the bottles and the like?
There was DNA, on the bottle, there was. But again, she was there. It was on some kind of a.
The wine
Yeah,
thing.
some kind of a wine cooler or something. So moving on to the cross appeal, the aggravated kidnapping statute provides that whoever commits kidnapping
There has to be the kidnapping of the baby, of course.
of the baby, yes,
right,
yes,
right,
for sure,
right.
that's, yeah. There has to be serious bodily injury, and that's permanent disfigurement, protracted loss,
And it's not the potential for serious bodily injury, it's serious bodily injury.
just serious bodily injury, exactly. But none of the,
And didn't we have that here?
no,
You have the testimony of the doctor, and you have the testimony of folks who saw the baby, who didn't need expert testimony to put two and two together, saying that if you look at the baby and you look at the way the baby looked after the baby was I'm not going to say delivered, because that seems to connote something medical.
Yeah.
Not a murder. But in the testimony of the doctor saying if you deprive the baby of the oxygen being tethered to his mother, that these are the kinds of things that end up happening. So why don't we have that here?
well, I think what the motion for a new trial judge said was that argument was speculative, because they really needed an expert to prove that there was actually harm to the baby. I mean, if the baby was delivered and if there was a lack of oxygen to the baby, but that wasn't proven. The baby was cold and the baby was small, and those were the only negative, physical characteristics of the baby. There was nothing else. There was no.
So you have to inflict serious bodily injury thereby upon another person.
That's right, and there just wasn't that here.
So and then serious bodily injuries, permanent disfigurement, impairments.
That's right, or substantial risk of death.
Substantial risk of death.
Yeah.
How
That
can you
just-
say
that's
there
just
was
not-
no substantial risk of death where somebody who's not a doctor, who doesn't perform surgery, cut open the person who he's just killed, or she is just killed, and not have a substantial risk of injury or death to the,
But I think that Judge Kent Smith,
Walker.
Kent Walker, said that was speculative, that
I
there was just no
under- no, I understand.
proof.
I understand that that's what the judge said, but isn't it fair to say that anyone, it's not something that needs expert testimony?
Well, she seemed to think it needed expert testimony.
Well, perhaps, but the question is whether that was an error. And so I still go back to the testimony at trial. You have the coroner or the medical examiner who testifies, says, I can't even call this a cesarean section.
That's exactly right.
You
That's
have
exactly
the
right.
doctor who testifies and says that having a cesarean section is a medical procedure that's serious, where we're not talking about just kind of run-of-the-mill day surgery. And so why does the jury, so if, at its threshold, experts are only supposed to be listened to if they're helpful. And if it's not helpful to the jury to say, here's what the instruction is, and how can I not find likelihood of serious injury or death when the baby was extracted from this woman in this way, why do I need an expert to draw that conclusion?
Well, I think that, I believe that there should have been an expert there, or at least there should have been serious bodily injury, and it just wasn't, and substantial risk of death. He was trained in some way, somehow trained, and the baby did live, and the baby was only cold and small, not even in any way physically impaired. Without any other questions, I will rest on my brief. Thank you.
Okay, thank you. Okay, Attorney Lazar.
Good morning, Ellen Lazar for the Commonwealth. The Commonwealth asks this court to affirm the defendant's conviction and the denial of her new trial motion and to reverse the order partially allowing the defendant's motion for a required finding of not guilty.
Counsel, will you begin with that last issue that we just finished discussing?
Yes, Your Honor.
Do we need expert testimony, as the trial motion judge found here, where you have these other pieces that the jury could connect on their own to see whether it meets the instruction for the return of the verdict here? Do we need it? I know
Yes.
what you said in your brief, but counsel comes up and says, hey, this is all stuff that we've never really kind of crystallized in this way.
Right, Your Honor. First, I would say no, you would not need expert testimony because I believe that it is a matter of common knowledge that any person would know that if you kill a pregnant woman, there's a substantial risk of death to the unborn fetus. But I would also say that here there was medical testimony. Dr. Paul Dunn testified that when a mother's heart stops beating, there is no blood pressure, so no blood or oxygen flowing to the baby. And he explained the very short time frame during which a fetus can then be saved in those circumstances. And he also described the process of performing a cesarean section, which, as you noted, is not a simple procedure.
Is the key word the statute risk?
Substantial risk of death.
But should we be focusing on the risk?
Yes, that there did not need to be shown an actual physical injury to this fetus. And I also cited two cases, Ronke and Chapman, which talk about substantial risk of death to a fetus, even if there is no visible external injury to the baby. And interestingly enough, here at trial, the defense asked Judge Kenton Walker not to instruct on felony murder with aggravated kidnapping, arguing that there had been no expert testimony to show substantial risk of death to the fetus, and Judge Kenton Walker rejected that request, and she specifically rejected Commonwealth versus Scott, the very case that she relied on in allowing or partially allowing the required finding, because she said at trial, I think that if you put all of these things together, not only that, there was of course evidence regarding the injuries to the victim, which included not only this 9-inch incision in her abdomen, her reproductive organs were missing, her bowel was hanging out of that incision, but she had also sustained blunt force trauma to the head, had multiple lacerations and skull fractures, was strangled with a ligature. So I think that, again, just based on common sense, but in addition, the medical evidence that was presented, that there was ample evidence from which the jury could have found that there was a substantial risk of death to the baby, which showed serious bodily injury for purposes of aggravated kidnapping. With regard to the defendant's motion for a new trial, the judge correctly found that the defendant failed to sustain her ineffectiveness claim. As reflected in trial counsel's affidavit and also in the judge's finding, counsel made a strategic choice not to present an expert witness on cell site location information. The defense raised at trial was that somebody else killed the victim and then took the baby from her body and gave it to the defendant. This defense accounted for the fact that the defendant had been found in possession of the baby, and also in the victim's apartment, the defendant's DNA and fingerprint were found on.
She was friendly with the victim though, right?
There was one person who testified that they were acquaintances or friends. I think that was the landlord. Several other people, including the defendant's live-in boyfriend, said that they were not friends. And in fact, when the defendant's boyfriend testified and said that he got a call from the defendant saying that she was giving the victim a ride somewhere, that seems strange because they were not friends. But even putting that aside, even if they were friends or acquaintances, there was evidence that after 8 p.m. on July 23rd, and the crime is alleged to have happened overnight from the 23rd into the 24th, after 8 p.m., that the victim and the defendant were together at this package store, that the victim was buying wine coolers. And then in the victim's apartment are 2 wine coolers. One has the defendant's DNA on the mouth of the bottle. The other one has the defendant's fingerprint on the bottle. And again, the defendant has the victim's baby. So all of this needs to be accounted for.
What do we make on 33E of the roles of the other people and her role in this?
I think what we make of that is that all of these alleged weaknesses in the evidence and all of the evidence of an alleged third-party culprit, all of those arguments were made to the jury. This was the defense that was raised at trial. The defendant herself says in the brief that this defense was masterfully presented. The jury rejected that defense. I would just like to, as to 2 things that the defendant states. One, to the extent that the defendant is relying upon her own affidavit that she submitted to the motion judge, the judge explicitly found that that affidavit was not credible. Secondly, the defendant repeatedly says today and in her brief that the blood or DNA of Mr. Rodriguez was found mixed with the baby's blood or DNA on one of the tape dispensers, and that is actually not a correct characterization of that forensic evidence. The evidence was that there was a red-brown stain in the tape dispenser that was found to be blood. The major DNA profile matched the baby, and there was a minor DNA profile from which Mr. Rodriguez could not be excluded as a potential contributor. So it's an overstatement of that evidence to say that Mr. Rodriguez's blood and the baby's blood were found mixed on this dispenser. And I think...
I'm sorry, did the jury have to believe that Rodriguez was not involved?
Absolutely not. Absolutely not. Certainly, Your Honor, the defendant could have committed this crime with other people, and there absolutely did not have to be a showing that...
Was the jury instructed that way? As far as she's either a principal or an aider and abetter?
I don't believe so. I think it was just presented, it was not presented on a joint venture theory. They were not instructed on joint venture. But still, there's no reason that the jury would have to find that none of these 4 or 5 men had anything to do with a cleanup or anything else in order for them to find the defendant guilty. With regard to the defendant's other 33E arguments, with regard to her mental health, Judge Kenton Walker found, after hearing testimony from trial counsel on a hearing on the motion for a new trial, that the defendant explicitly rejected a mental health defense after full consultation with her attorney. So the defendant is now supporting her request for a reduction in the verdict on affidavits supplied by a mental health expert, Dr. Nancy Byatt, after trial. But Dr. Byatt's opinion is seriously weakened by the fact that it relies upon the exact version of events that was rejected by the jury. Dr. Byatt gives an opinion that the defendant may have accepted the baby from someone else who killed the victim because the defendant may have been suffering from postpartum depression. This was the exact argument that the defendant made at trial, that someone else killed the victim and took the baby and gave it to the defendant, and this is what was rejected by the jury. In addition, to put forth a defense at trial that she was suffering from postpartum depression, the defendant would have had to present some evidence about when she lost her own baby. And that would have actually strengthened the case because it would have shown that for weeks or months, the defendant pretended to be pregnant. And this would have seriously undermined any claim that unexpectedly, on the night of the murder, somebody called her to come get this baby, if she was walking around for 3 months pretending that she was still pregnant after having lost her own baby. The cases that the defendant cites in support of her 33E argument are all cases where there is an impulsive, spontaneous act with no apparent motive. This case is not like any of those cases. There was ample evidence that this was premeditated for days, weeks, or months, and there were multiple motives presented. This is not a case like those upon which the defendant relies. So the Commonwealth would ask this court to affirm the conviction of first-degree murder.